one more, and the best evidence principle, rule of best evidence. So that is there. That is also there. So these are the ingredients for our today's quick lecture, though short one, but it has got heavy burden of proof and substantiating the facts in case, relevant, irrelevant, and then oral and documental and and electronic evidence. So these three.
వెళ్ళి నేను లేకుండానే వాగుతుంది.
Good evening, Satyanarayana garu. Okay, fine. So this is the basic. So let me go to the presentation part. Then we can. I urge again. I request you kindly mute yourself, and whoever wants to have any questions or concerns to be raised can raise at the end of the session while we seamlessly steer through our current session, which is in focus. That's my humble request. So no crosstalk, so that others' attention is not diverted. At the same time, people can learn from the issue. But here, one more rider or disclaimer is the examples quoted or the sections are these related to the relevant acts pertain, but the examples quoted may be fictional in nature, may be in reality. So take it for granted that if Satyanarayana is mentioned in one case, our Manti Pragada is not in focus. So it's only exemplification which we are trying to deal. So most of the cases now, these were cited, and now I'll be citing some more case laws also. So please be attentive and do homework. This is not for meaning people who are not practicing or some freshers, but at the same time, all are literate enough to extrapolate what has been discussed or enlightened in this session, so that you can do some homework and come back by the next session. The doubts you have, we can bridge the gap. Thank you very much. After my presentation, I'll just, I'm not done the presentation as such, but I will be teaching or browsing through my outline where one can have a fair idea of what can be dealt with. Okay. Mahesh Garu, please enable my sharing, sir.
Okay, sir.
ఇంకేం అర్థం కాదు అటు చూడు
Sir, something wrong, sir. Host disabled attendee screen sharing, sir. Now it's come, sir. Now it's come. So, please, my screen is visible, sir. Anybody can respond yes, because I will not be seeing what is being displayed. Somebody can say yes. Hello. Sir, somebody can give thumbs up or something so that I can understand my screen is being displayed. So today I have picked up the case already mentioned, State of Maharashtra versus Dr. Praful Bhosle. So the crux of this matter is to focusing on specific electronics evidence involved, the challenges raised, and the court reasoning. So if you go to the so I want to directly. So instead of me explaining, I'm taking the help of the net, and directly it cuts short our time of interaction. At the same time, it is depicting a good picture. So the case summary is. It's a landmark judgment wherein the Supreme Court upheld the validity of video conferencing as a vital tool for collecting evidence where the witness may not be conveniently examined in the court. So, what are the relevant portions, relevant sections to fall back upon on CRPC is Section 273, and as already pre, pre analyzed and mentioned that Section 3 of the Indian Evidence Act is in picture. So, facts of the case. What is the fact of the case? Here, the complainant's wife was suffering from terminal cancer. Dr. Greenberg examined the complainant's wife, USA, who was residing in USA, has opined that she was inoperable and should be treated only with the medication. Thereafter, the complainant and his wife consulted the respondent, Dr. A.K. Mukherjee, who is a consulting surgeon for the last 40 years. So, the US Dr. Greenberg told that she is inoperable. And the family doctor or the family physician is Dr. A.K. Mukherjee, who is family doctor means he is for the last 40 years he has been the family doctor. So they have more confidence in the back home, Dr. Mukherjee than the Dr. Greenberg. So despite being aware of Dr. Greenberg's opinion, the respondent suggested surgery to remove the uterus and operated on the complainant's wife, causing the complainant's wife to suffer terrible physical torture and mental agony till her death. So, this being the narrative. Now, Maharashtra Medical Council in an inquiry held the respondent guilty. So, who was made guilty? The Dr. Greenberg, Ernest Greenberg. The doctor in question is Dr. Ernest Greenberg, who was unwell and not willing to come to India to testify before the court. So, Dr. Greenberg, Ernest Greenberg was respondent and held guilty also. So, he, however, showed his assent to testify through video conferencing. The prosecution applied to examine Dr. Greenberg through video conferencing. So, if you go to the fact, it is about the Supreme Court who upheld the validity of the video conferencing as a vital tool for collecting evidence. So now, if you draw back to my citation, me developing an expert system or a decision support system at BHL, we have developed, meaning I am the prime developer in that project, and I have modeled all the rules by the consultant, and built up an expert system which replaces the consultant who is in USA only. So only after due decisions, after some preliminary symptoms conferred by them, only then we used to call him. Likewise here, that's also at that time video conferencing was there, not there, but mere phone call was there, and email was there. So we were corresponding with the American consultant, same way as this video conferencing they have relied upon, and Supreme Court has accepted video conferencing as a admissible evidence. That is the key part of our discussion and today's subject matter to discuss. Now, here is the sincere request from Dr. Ernest Greenberg that he was unwell and is willing to come forward and cooperate in the investigation as he was the prime respondent. He was not able to come to India to give the confessions or any interrogation or whatever it may be. So he was willing to testify before the court through the video conference. So now Supreme Court, what I told here. Specific electronic evidence involved, the challenges raised, and the court's reasoning. Now, here, second part we finished. Evidence involved, we know. Challenges raised, we know. Now, about the court's reasoning. So, what about the court's reasoning? So, by that cause itself, you being some senior lawyers and some criminal lawyers who can apply the mind that what could have gone wrong, what could have been admitted, what is like, you know, the facts in the case, then relevant, irrelevant, then so many things are there, section 3, which deals, and then admissibility part of it can be thought about in this arena of electronic evidence. So, now coming back to or entering the shoes of the Supreme Court, which has observed that physical presence is not necessary. So, sir, somebody wants to speak? Okay, thank you. So, the Supreme Court opined that physical presence is not necessary. So, Dr. Ernest Greenberg has been absolved of his physical travel from America. Sir, can you please?
Already matter is, just see the last page, my lord. Just see the last page. The matter is being heard by Mr. Khanna. Honorable Justice Khanna, my lord.
Sir, can Mahesh Garu please mute everybody, sir?
What is that matter about?
Yes, that matter is, my lord, effectuation of Justice Verma Committee recommendation, Justice Venkatchalia Commission.
What they deal with.
And my prayer,
you can intervene in that matter. Let your officers as interested parties.
I'm only,
We don't want to add to the burden.
I'm only requesting, my lord.
And not board.
No, my lord. There are, my lord, it's not adversarial petition. I'm only requesting, Lord, just simply tag with it.
How can we issue a writ that the union member states will take steps to eradicate superstition? My lord, for people to develop a rational temper.
Mahesh Garu.
Why is the founding fathers and mothers of the Constitution, they put it in the directive principles of state policy. And we now virtually issue a writ. No, I'm only to see how much time we have spent.
I'm only requesting, madam.
Sir, can we proceed? Some crosstalk was going on. Okay, the Supreme Court opined that physical presence is not necessary. So the challenges we faced, or the challenges in this case faced, were resolved by bridging the gap through video conferencing, and that made the proximity happen. What is the proximity? We are click away from any location on the globe. At the same time, through video conferencing, they are face to face. Now, that absolved them of the physical presence in India, but his assent to cooperate in the investigation came through. Next, we can also consider the electronic presence as presence under the section 273. Just now we jumped into the relevant sections. Section 3 of Indian Evidence Act and Section 273 of the Criminal Procedure Code. So, as Section 273 of the Criminal Procedure Code states that evidence must be recorded in the presence of the accused. So, definitely video conferencing. Now I am facing you all. You are also facing me. Now the section is fulfilled. Section's requirement or section's intention is fulfilled. Likewise, Section 3 of the Indian Evidence Act states that evidence can be both oral, documentary, and electronics record. This electronics record has been added after the amendment. So, all these three can be produced as evidence. Now, before going to the conclusion, this Supreme Court allowed video conferencing and said about the advancement of the science and technology, and the evidence will be recorded in the studio, court, and the judicial officer. Judicial officer will be present at the time.
Just see the last page, Malak. Just see the last page. The matter is being heard by Mr. Khanna. This is Justice, Honorable Justice Khanna, Malak. I am requesting only just simply tag with Malak. If lordship don't want to issue notice,
What is that matter about?
yes, that matter is, Malak, effectuation of Justice Verma Committee recommendation, Justice Venkat Chalia Commission.
With what we deal with. Then
And my prayer be,
you can intervene in that matter. Let your officers as an interested person.
I'm only,
We don't want to add to the burden of
I'm only requesting, Malak.
Khanna's board.
No, Malak. There are, Malak, it's not adversarial petition. I'm only requesting, lordship, just simply tag with it.
How can we issue a writ that the union in the state should take steps to eradicate superstition,
Malak,
for people to develop a rational temper? The Constitution, why is the founding fathers and mothers of the Constitution taking the directive principles of state policy? And we now virtually issue a writ.
no, I'm only,
See how much time you have spent.
I'm only requesting, madam.
Matter which
Yes, I'm only requesting, madam. Because there is one matter is going on in court too. Just see the writ petition civil 67 up to 2022, madam. Writ petition civil 67 up to 2020.
Am I audible? Am I audible, please? Mahesh Garu, please unmute me alone. Because of the crosstalk, I muted everybody. Am I audible? Madam, please give host.
ఏమైందంటే మీరు ఒక్కళ్ళే హోస్ట్ ఉన్నారు ఇప్పుడు మహేష్ కూడా హోస్ట్
Oh my God. Then,
అందువల్ల ప్రాబ్లం అవుతుంది దానికి.
okay.
మీరు ఒకసారి తనని హోస్ట్ చేసేస్తే ఎగ్నా లీగల్ అని ఎక్కడన్నా నాకు కనిపిస్తుంది చూడండి,
అవును.
దాన్ని హోస్ట్ చేయండి.
Okay, I'm trying.
Then you will get a chance అన్నమాట. మీరు ఏదన్నా ఏమున్నా మీరు కంటిన్యూ చేయండి క్లాస్ ని.
చేస్తున్నాను. అది క్రాస్ టాక్ ఎవరో వీడియో పెట్టారు మేడం, ఎవరో
ఏం వీడియో పెట్టారు?
అది సుప్రీంకోర్టు డైరెక్ట్ వీడియో ఇక్కడ నడుస్తుంది. ఎవరు
ఎవరైనా
అది? అందులో ఐ కుడ్ నాట్ సే, దట్స్ వై ఐ మ్యూటెడ్ ఎవ్రీబడి.
ఓకే రైట్ అండి. మీరు నాకు మహేష్ని కానీ నాకైతే ఫోన్ ఆపరేట్ చేయలేదు, అది నా ప్రాబ్లం.
Okay.
ఎగ్నా లీగల్ గానే ఉంది కదా, దాన్ని హోస్ట్ చేసేయండి. ఎగ్నా లీగల్ అని ఒక స్క్రీన్ కనిపిస్తుంది కదా,
అది కనబడుతుంది. దాన్ని
దాన్ని రైట్ సైడ్ లో హోస్ట్ అనే ఎక్స్ప్రెషన్ హోస్ట్ చేయండి. వాడిని
కోహోస్ట్ చేస్తున్నాను.
చేయండి సార్.
ఇప్పుడు వచ్చిందా మహేష్? కోహోస్ట్ చేశాను.
ఆయనకు
వచ్చింది. ఇప్పుడు థమ్స్ అప్ లేపాడు.
Okay, sir.
రైట్.
Thank you, sir.
Mute everybody and unmute on me alone. అయిపోయింది మేడం.
Thank you, sir.
అయిపోయింది. పెట్టాలా మేడం?
సార్
ఓకే. ఓకే మహేష్ గారు,
Sir.
మ్యూటెడ్ ఎవ్రీబడి, రైట్?
Okay, sir.
Again, now I am sharing. So now we are of the third stage where opinion of the court is being dealt or discussed about. See, the physical presence have been absolved, and the video conferencing has bridged the gap where he is far off at USA. Dr. Ernest Greenberg would come online face to face because the evidence must be recorded in the presence of the accused. So he knows that he is being screened. He knows that he is very much alive and kicking and speaking out of his own personal opinion and observation of the patient, and his opinion given about the so and so part to be operated, and then so and so thing is his prognosis, what is going to happen and what can happen. But after the home or family physician was consulted, these are the things which led to the entire story. And here, admissibility of electronic evidence is the crux where it bridges the gap. Now, what are the sections involved? Section 273 of the CRPC and Section 3 of the Indian Evidence Act, which state that evidence can be both oral, documentary, and electronics, as produced as evidence. To this, Supreme Court allowed video conferencing and said about the advancement of science and technology, and the evidence will be recorded in the studio, court, and a judicial officer will be present at that time. So what has been concluded? The Indian legal system has recognized and embraced video conferencing as an extremely effective instrument to collect evidence, as it aids in avoiding unnecessary adjournments of the cases and also saves the parties from the cost borne on transportation and other inconveniences that may arise. So this is about the state of Maharashtra and Praful B. Desai as a case law, and we can adduce electronic evidence to justify our claims or proceed with the adjudication process, as this is a major landmark case. Now coming to additional extrapolations of what can be understood, what can be discussed about, and how do we go about in adducing electronic evidence. So let us go to section 65A and the 65B. 65A is a declaration part. 65B is the operational part, where we have to prove what has been declared or defined in 65A, and 65B is to prove and its interplay with IPC, CRPC, and Indian Evidence Act. As all advocates, we know how do we leverage the evidence collected. Now talking about IT Act section 65B, what are the key provisions regarding the admissibility of this electronic evidence, and the relevant sections for the context as those related to evidence, confessions, and expert opinions. Yesterday or last session we talked about expert opinion, and now we are pretty well known about 161 statements. About the criminal confessions, anybody can write in the chat box what is the relevant section with regard to confessions. I am seeing. I want to see interaction. We will not unmute them, but I want to know how many people are aware about the confessions part. Direct message you can send to me, if not to the group. Okay, without much ado, it is 164. So about the confessions. Now we should know about the interplay of laws. So what are the interplay of laws in the realms of electronic evidence? So these are to be borne in mind, that what encompasses the realm of electronic evidence, because the latest Bharatiya Saksha Adhinam has brought in the definition of document. Earlier, there was only like section 3 and corresponding sections were making a mention anything can be scribed on a substance, a material. So many definitions are there about the evidence. So these have been further elongated and extrapolated to a simple word called document. Document can be an image, document can be a video, document can be an electronic record. So you better just consult the Bharatiya Saksha Adhinam on the evidence part, on the document definition part. Now comes the electronic evidence in the case. So now that the floor is open, not to unmute yourself, but on the mental aspect, what is the nature of electronic evidence involved? We have to describe the type of the electronic evidence involved. Example, emails, digital documentation, electronic records. Now, kind of all this pulled together, role of this evidence collected, that is, role of this electronic evidence collected should be in our mind, regurgitating or going like before the screen. What has happened? So how this particular electronic evidence gathered is used in the case to prove a guilt, or to establish a timeline, or establish and corroborate with the witness testimony. All these have to go through like a film reeling continuously, and one stone, like you keep on throwing stones in the glass, if you find one glass, it will hit. Likewise, the electronic, those are all funneled into electronic record, and now this electronic how to be used, whether to prove somebody guilty, whether to establish a timeline. Always I will write in my petitions are there, so and so, make sure timestamp is there, date stamp is there, then the context. So all these should come as a reel before you as a cyber forensic analyst or a cyber crime handling advocate, be it a technology lawyer. So once more I repeat, to prove a guilt, to establish a timeline, to corroborate and witness a testimony. Next, what are the challenges in admissibility? See, we have to identify the potential challenges with regard to electronic evidence. Like we have studied in the past 3 classes, what is authentication, what is confidentiality, what is integrity, and what is availability. That's all these combined triad of a security. So it should be a secure environment. I have also shown you VPN, virtual private network. So now these challenges faced in admissibility is to identify potential challenges. For what? When we are trying to adduce an evidence, whether it is authentic, whether it has got the due integrity, and following the out of the golden rules of evidence, the best evidence rule we follow. Followed? So this is my crux. Now coming to court's analysis and decisions. Just now we have regurgitated the case law in picture, that how they have come to the opinion and how they have done away with the physical presence of the guilty or accused, and a proper court officer to be present during the entire interaction. All these come into picture because this forms the part of the court's analysis and the decision making process. So what are the legal questions addressed by the court? Just now, where legal challenges faced were put before the court, and the court has opined and come up with a solution of video conferencing. Now, what is the reasoning mechanism? So, whether to admit or reject. What is admit? Definitely, due to paucity and the increase in the cost borne in travel and the logistics issue, and we know that he cannot come because of his ill health. So, doctor, see, unlike India now there is a certain legal framework which are binding them to be accountable. Prior to this latest act, there is no accountability of an Indian doctor coming into picture and watching that I did this, and again this law has brought doctors accountability into picture. Likewise, in America, where I lived and had the experience, so doctor means highest premium of insurance they pay. Why? Why? So all these are malpractice ensured, because I'll tell you one more thing. My wife, being a gynecologist earlier, she was harping, saying that oh, too many medical insurance bills. So very difficult. So anyway, that is real. So, and the doctor's consultation fees also too high. At the same time, the medical insurance is also too high. Why? Because of the malpractice protection, which I will tell you live incident. A girl who is operated during cesarean, the medical doctor or the gynecologist and the team involved sign a certificate. Till up the age of 8 years, they are bound and they are accountable to the ill health or positive health of the baby or the child which they have delivered through C-section, that is cesarean. So such is the accountability in America, right? So the evidence here is to such an extent whether to be admitted or rejected, coming to electronic evidence. Well, here accountability comes into picture, where they pin particular transaction or pin particular electronic evidence, and it is accountable till the case is dismissed or disposed. Followed? That is being admitted or rejected. Rejecting means the counsel, the counsel of the accused or counsel of the other of the parties, they take all the efforts in seeing to it the court admits this evidence. Now, relevancy of the section 65B. So, I just told you, 65A declares, 65B gives you the modus operandi. Now, we are coming to the last end because time is also there, but it's a quick one because interesting one. Hundreds of cases I can give you, but this is a clear anecdote, which is a fact. That's why it has become a landmark judgment. Now, the implications and the conclusions. What is the impact of the case when we have really gone through the Bosle's case, where family doctor Mukherjee has gave his opinion, and the American doctor, where the victim was lying in state or lying in America. Lying in state means after the death. So that is different issue. The whole thing brought to and made it a case law. So the very fact she lived in America and she was diagnosed by the Dr. Ernest Greenberg. So the impact of the case has given a reference. That's why it has become a case law. Now, what are the best practices involved? Every screenshot, every video, every interactive session is recorded and paused. Recorded and paused, summary is taken. Like Madam Sridevi has asked the AI companion to, while I'm speaking, it is listening to my English and translating into text. So speech to text, it's a co-pilot which is working while I'm speaking. It's throwing up the today she has not switched on, but in earlier sessions, the AI companion was invoked, and AI companion was listening to me and converting speech into text. Likewise, the conclusion remains that the Supreme Court reiterated the main points, emphasizing the importance of the legal framework involved for admitting the electronic evidence. So please remember the admissibility of electronic evidence in the case law, State of Maharashtra versus Dr. Praful Bhosle. So some more to talk about the electronic evidence. We can talk about CCTV footages and other transmitted images and WhatsApp messages. So many things are there. Now, I recently, in the last class, I told you section 196 and section 299. Section 192 is a major issue now. Why? Because just in UP or just in Chhattisgarh, one simple statement in a WhatsApp group has led to the riot. So what is a riot? One community is accusing the other community. I don't want to name the communities here, but this is a real fact. So which section is inviting? Section 192. So one provoking statement has led to a riot. Likewise, in UP, where mob lynching is taking place and the cow vigilantes are in action. I don't want to name the community, you know the context. So it is like creating a difference of religious belief system and religious belief system, as well as it is creating hatred among two communities. So what is the section? 299. What is the other section? 196. What is the section which is identifying the provoking statement of writing? 192. So these three are valid sections to be utilized for left and right in the current scenario in this India. Okay. So this you have to bear in mind. These are very, very important ones, so that you can leverage in your own cases, where most of the cases are being handled in these three main areas. Other than that, we know what is deep faking and other things. So which are leading to further extrapolations and leveraging of this IT Act 2000 and amendments thereof. So, search and seizure operations also you should know. So then I want to just reflect upon the certification involved. See, the court is also expecting a certificate to be issued by the owner of the electronic record, be it a computer, be it a pen drive, be it a be it a smartphone. So in search and seizure, it has to, the law enforcement agency has to seize that particular device. And when that particular device is seized, the owner of the electronic device has to certify that this device is mine. Say, iPhone is there. So what is the operating system? iOS. Then what is the model? iPhone 15. Then what is the operating system? What is the model? Then how much memory it has, whether it has got a SD card or not. Then whether it is having a multiple or multi-camera provision is there. Then what is the front-end camera and what is the back-end camera? What their resolutions, megapixels. All this you have to define in that certificate. So this is also this is what a prerequisite. Now coming to interaction between parties, digital certificate is a prerequisite, and digital certificate obtaining and the one who gives also has to certify that this certificate was given to Mr. Jaikar, this was given to Madam so and so. So all these have to be given as a certificate, and this certificate holds as the primary evidence. Then in prior Indian Evidence Act, which was secondary, has been made primary here in the Bharatiya Saksha Adhinam. So these are all the things, what has been leveraged, what has been extrapolated, and what has been amended has to be borne in mind. So I want to talk about on the admissibility also. So there are concepts of chain of custody. See, chain of custody is also is in similar to mutation. So like this property has been mutated from or transferred from X to Y, Y to Z, Z to A to B, C. Like the chain of custody also has the stamps of ownership where evidence can be adduced out of pulling out this chain of custody. You remember that. Next, drawing parallels from the Indian evidence golden rules, best evidence policy. Best evidence policy is also to be taken into consideration where original electronic evidence was presented or if copies were used or any related challenges involved has to be brought to the notice of the court. Next comes the hearsay rule. If the hearsay rule analyze it with electronic evidence, was it a hearsay and how the court has addressed this issue. Then comes me as a certified information systems auditor as well as a digital forensic expert or analyst. I have to submit my expert testimony and I have to narrate in my report what are the factors which I have considered in authenticating or interpreting the electronic evidence. So entire my journey has to narrate from collecting the evidence to doing the analysis and giving a report, conclusive in nature that this is the final evidence which has gathered and can be interpreted as a admissible evidence in the court of law. Now again, regurgitating the court's reasoning. So admissibility division. So admissibility division is whether to admit or reject. So that is again, what are the basis? Legal basis, analysis of the evidence, and the impact of the case. So all these will be considered to admit or reject. Why? End result is the outcome. Then it includes the weightage of the evidence and its credibility to that extent. Then you can think of preserving an electronic evidence, be it in any memory device, or we all have thumb drive, pen drive, or whatever it may be, external drive. All these can be considered how to preserve the electronic evidence. Conclusion. So, what are the key findings of the analysis? And let's reiterate the importance of addressing the electronic evidence admissibility and its challenges. So we have a fair view by now. We understood about the admissibility of the electronic evidence and the Supreme Court's directive and the action in the case law of Dr. Bhosle versus our union government of Maharashtra and the Bhosle's case. State of Maharashtra versus Dr. Praful Bhosle's case. So with this, I conclude. Any questions or concerns you may express so that we can take up in the next session and we can now unmute anybody who wants to clarify last session's issues. If not, we can call it a day for this session. And I once again seek your forgiveness for joining late. I hope I am forgiven. And I appreciate your silent, attentive patience listening. At the same time, keeping the decorum of not giving any crosstalk or not playing any videos crosstalk so that it distracts the fellow learners and participants who are trying to eagerly catch up what I am trying to share and care about the knowledge. Thank you very much for the patient listening and God bless you all. We'll catch up next week. And let me conclude with this that now the floor is open for you to unmute and have any sessions, interactive sessions.
Good evening, sir. Sir, are you able to listen to me?
Yes, madam. Go ahead.
Yeah. Sir, you told something regarding in BNS, there was a change when compared to Indian Evidence Act. I didn't get that. Can you repeat?
Okay, ma'am. Just remember 192, 196, 299 in terms of provocative statements in a social media or in fact oral, public or in social media. Social media consists of Instagram, X, WhatsApp and so on, which let me talk about 192. Any statement made to invoke or provocate or instigate which leads to a riot or it's a mob attack called riot. So that is attracting, invoking section 192 of BNSS. Then 196, if you are trying to create a rift between or hatred between communities, no communities mentioned, two communities, it attracts 196. Then 299, if you are trying to create a hatred between two religious communities, 299 is and hurting the religious sentiments, it attracts 299. These were not there earlier. And one
Thank
more
you, sir.
addition.
Thank you.
Welcome, madam. Nagalakshmi, Sirisha. Very good.
Yes.
See, Evidence Act, as amended, also included the electronic evidence. Section 3 law. Earlier it was oral evidence and documentary evidence. Now electronic record and electronic document has been added in Amendment 2 Indian Evidence Act 1872.
Thank you, sir. Thank you.
Welcome, madam. Welcome. Anybody has any question or concern?
Sir, good evening, sir.
Very good evening, Naresh Reddy garu. Cheppandi.
Sir, ఇప్పుడు వాట్సాప్ మెసేజెస్ అండ్ నార్మల్ టెక్స్ట్ మెసేజెస్ ఎన్ఐ యాక్ట్ కి ఎవిడెన్స్ కింద ఉపయోగపడతాయి సార్?
ఎన్ఐ యాక్టా?
Yes, like check
negotiable
bounced.
instrument.
Yes, sir.
Sir. Any evidence, whether it is short message service, that is SMS, is an
Yes, sir.
electronic medium you have used. It is an evidence.
ఓకే, థ్యాంక్ యూ సార్. అంటే ద టైమ్ ఆఫ్ చెక్
NI
బౌన్సింగ్
Act
టైంలో మనం
everything
Any-
under
everything.
Indian Evidence Act and amendments
Okay.
thereof is one aspect, and Bharatiya Sakshya Adhinam is the another aspect. Currently,
Okay.
we are in the new Hindi laws, BNSS, and
Yes,
Sakshya
sir.
Adhinam.
it is 65B only, yes, sir?
Yes, sir. 65B.
Yes, thank you.
65A declares, defines
Okay.
what it is. And the operating, like what is 499, sir? IPC 499 ఏంటి?
Hello?
Anyway, defamation.
Defamation, sir. Yes, sir.
దాని పనిష్మెంట్ 500 ఉంటుంది.
Yes, sir.
వీళ్ళు ఎలానే క్లబ్ చేశారు 65A 65B అని.
Okay, sir.
అంతే.
Okay, thank you, sir.
వెల్కమ్. ఎనీథింగ్ ఎల్స్ సార్?
సార్ ఒక చిన్న క్లారిటీ కావాలి సార్. సార్ ఇప్పుడు వాట్సాప్ మెసేజ్ జనరల్లీ మనం స్క్రీన్ షాట్ తీసి అది ఎవిడెన్స్ కింద ఇస్తాం కదా సార్. ఇప్పుడు అది ఏదైనా అడ్మిసిబుల్ అయినా, లేకపోతే ఇప్పుడు ఆ ఫోన్ ఏది ఉంది, ఏ ఫోన్ నుంచి తీశారు, ఇవన్నీ కూడా కావాలా సార్? అది నాకు క్లారిటీ.
గివ్ 1 minute. మీ ఇందాక చెప్పాను అంతా. డిజిటల్ సర్టిఫికేట్ హాస్ టు బి గివెన్. 1 minute, just 1 minute.
ఓకే.
My audio is open, but I am just taking some water. Now I am visible, madam. చెప్పండి నాగలక్ష్మి గారు.
ఎస్ సార్.
So, just now my conclusion was the owner of the electronic device has to certify that I am the owner. If it is iPhone 15 is the model. If it is iPhone, what is the operating system? iOS is the operating system. Then how much memory it has, how many front-end cameras it has, multiple. then how many back-end cameras it has got, multiple, then what is the size and pictures and features, all these you have to give a certificate. That owner has to endorse it or give as a certificate through which this ట్రాన్స్పైర్డ్. అంటే ఇందాక మన నరేష్ రెడ్డి గారు ఏమన్నారు, కి సార్ ఎన్ఐ యాక్ట్ కెన్ బి ఏ యాక్ట్ అయితే సార్ సబ్జెక్ట్ ఈజ్ ఎవిడెన్స్. వాట్ ఈస్ దట్ ఎవిడెన్స్? ఎలక్ట్రానిక్ ఎవిడెన్స్. అడ్మిసిబిలిటీ దేర్ టు. సో ఈమెయిల్ కాదు, ఇప్పుడు చెప్పాను కదా ఇందాకనే, ఈమెయిల్ ఉంది, సీసీటీవీ ఫుటేజ్ ఉంది, సెండ్ a వీడియో ఉంది, సెండ్ a షార్ట్ టెక్స్ట్ మెసేజ్, దట్ ఈస్ SMS, షార్ట్ మెసేజ్ సర్వీసెస్, దట్స్ ఆల్సో పార్ట్ ఆఫ్ ఇట్. Your doubt is clarified, madam. Nagalakshmi Sirisha garu. Naresh Reddy garu, you have any other additional question related to that?
No, sir. Thank you.
Response case lo vaadu text message nu ichinanduku he is bound.
Sir, excuse me, sir.
నేను ఒక కేసులో సింపుల్ he has used bad word in a SMS. నీళ్లు తాగిపించాను. అని.
Sir, thank you, sir. Thank you, sir.
How much is shelled out, but I am telling నీళ్లు తాగిపించాను.
Excuse me, sir. Sir, excuse me, sir.
One SMS.
Okay, sir. Okay, sir.
Sir, anything? Anybody else?
Excuse me, sir. వినిపిస్తుందా సార్?
వినిపిస్తుంది సార్, చెప్పండి.
సార్, ఇప్పుడు ఈ ఎలక్ట్రానిక్ డివైసెస్ వేరే వాళ్ళ దగ్గర నుంచి, వేరే వాళ్ళ డివైస్ నుంచి వాళ్ళు డిఫమేటరీ మెసేజ్ పంపించారు అనుకోండి, మరి అప్పుడు ఎట్లా సార్ అది? ఇప్పుడు సపోజ్ పక్కన వాళ్ళు ఫోన్ తీసుకొని ఆ ఫోన్ నుంచి వాళ్ళు ఎవరికైనా ఇట్లా డిఫమేటరీ మెసేజ్ కానీ అబ్సిన్ మెసేజ్ కానీ పంపించారు అనుకోండి, మరి అప్పుడు ఎట్లా ఎస్టాబ్లిష్ చేస్తాం మనం అది?
సార్, ఆల్ ద 3 classes you attended?
లేదు సార్, నేను ఈ రోజు అటెండ్ అయ్యాను సార్. నేను
ఓకే, ఫైన్. ఐ విల్ టెల్ యూ. Previous cases, one of our learner friend was sharing, sir, my bank account was rented.
Yes, sir. Yes, sir.
Through which
అదర్ పర్సన్ కి డెబిట్ కార్డ్ యూజ్ చేసినందుకు
ARK, you can unmute yourself.
సార్ మీరు చెప్పండి సార్.
చెప్తున్నా వినండి. సో నరేష్ గారు,
సార్,
so some friend was requested to lend his bank account so that he can siphon out. He did not directly use his bank account. He has used his friend's account. All deposits were coming one day. Sir, my agreement is after 1 lakh is collected in your amount, I will give you 5,000. So rest 95,000 I will take. Such is the situation. So all are party it. Then immediately I mentioned in the murder case, the one who committed or killed is of the same punishment, so as the witness too, who is under abatement. You got your answer, sir?
సార్,
Yes,
మరి
sir, got the answer.
ఇప్పుడు
Naresh
డివైస్
is silent. Naresh is silent.
సార్, డివైస్ ఇచ్చిన అతనికి తెలియదు సార్ అతను అట్లా చేస్తాడని, అప్పుడు ఎట్లా సార్ అది?
Sir, ignorance of
You
law
should
is no
take the
excuse, sir.
onus
Red
of
light.
that.
You have seen red light, you have to stop. Nobody has to teach you that you have to stop at a red line.
ఓకే,
Red light.
అయితే వైకేరియస్ లయబిలిటీ ఉంటుంది అంటారు సార్ అయితే?
ఖచ్చితంగా ఈజ్ ఆల్సో లయబుల్.
ఓకే,
అందుకనే ఎవరికి ఫోన్ ఇవ్వద్దు.
ఓకే. థ్యాంక్ యూ సార్.
వెల్కమ్.
సార్, ఇంకొకటి సార్, డిజిటల్ సర్టిఫికెట్ అని అన్నారు కదా, దాని గురించి కొంచెం చెప్పరా? డిజిటల్ సర్టిఫికెట్ అది ఎవరిస్తారు?
See, there are agencies. Last time నాకు థాట్ అన్నది, ఇప్పుడు జస్ట్ గూగుల్ చూసి చెప్తాను ఓవరాల్ది. ఇప్పుడు ఇండియాలో అప్పుడు నేను స్టార్టింగ్లో అంటే 2000 మాట చెప్తున్నాను, అప్పుడు ఓన్లీ 3 agencies were giving digital certificates in India. Now hundreds of people are giving digital certificates. Anybody can be giving a digital certificate. That is for your confidentiality, integrity and availability. But here in the context we are talking about the admissibility of evidence, because the crime purported or perpetrated through a device. Device is iPhone here. I am talking about the digital certificate where an LLP partner takes from a third party who is an authorized agency to give a digital certificate. That is a different context. Here the context is offense committed and the crime involved, and the admissibility of electronic evidence is the subject. Moot point here. So for that, the owner of the device has to give a digital certificate saying that this is my iPhone and it is the model iPhone 15. It is having a operating system iOS, and it has got memory. It has got front end cameras and back end cameras of this resolution. That's the thing. Hope you got better clarity.
Owner of the device must give those things.
Yes.
సార్ గుడ్ ఈవినింగ్.
Yes, sir. Good evening.
సార్ ఇప్పుడు పోలీస్ వాళ్ళు ఒక వ్యక్తిని అరెస్ట్ చేస్తున్నారు.
Ramakrishna, you have emerged after a long time.
No, sir, I am following on every class.
Okay, go ahead.
పోలీస్ వాళ్ళు ఒక వ్యక్తిని అరెస్ట్ చేస్తున్నారు. అరెస్ట్ చేసి అతని కన్ఫెషన్ సీజర్ పంచనామా చేస్తున్నాడు. అతని కన్ఫెషన్ లో వాళ్ళ దగ్గర ఎన్ని కేసెస్ పెండింగ్ ఉంటే అన్ని కేసెస్ లిస్ట్ రాసేస్తున్నారు. అన్ని కేసెస్ లిస్ట్ అంటే సారీ
ఈయన పేరు మీదనా, దొరికిన పేరు మీదనా?
నేను ఈ నంబర్ గల వ్యక్తికి ఫోన్ చేశాను, ఈ నంబర్ గల వ్యక్తి దగ్గర నుంచి ఇంత అమౌంట్ ఈ విధంగా చీట్ చేశాను, ఈ వేలో మాట్లాడాను. సో ఆ విధంగా వాళ్ళ దగ్గర కంప్లైంట్ ఫార్మాట్ ఉంటది కదా, యాజ్ ఇట్ ఈస్ ఈ కన్ఫెషన్ స్టేట్మెంట్ లో రికార్డ్ చేస్తున్నారు. అతని దగ్గర నుంచి సీజ్ చేసేది అంటే పోలీస్ వాళ్ళు సీజ్ చేసేది ఒక సెల్ ఫోన్, కీప్యాడ్ ఫోన్, ఒక సిమ్ కార్డ్.
సార్, device is a device, electronic device.
Yes, sir. Device is the device.
Whether Ramakrishna, whether it's a feature phone or a smartphone or a touch phone, whatever it may be, device is a device.
Device is a device.
Yes.
Sir, నా క్వశ్చన్ ఏంటంటే సార్,
చెప్పండి.
అయితే అతని దగ్గర నుంచి ఒక ఫోన్ అయితే సీజ్ చేస్తున్నారు. దాని IMEI నంబర్
ఎక్విప్మెంట్ ఐడెంటిఫికేషన్,
ఆ నంబర్ మెన్షన్ చేస్తున్నారు. ఆ IMEI నంబర్ లో ఈ సిమ్ కార్డ్స్ యూజ్ చేశారని చెప్పేసి ఇస్తున్నారు. ఓన్లీ అది ఓరల్లీ టైపుడ్.
నా దగ్గరకు వస్తే అది వేరే అయిపోతుంది. See, you may be implicated, Ramakrishna. See, I don't want to, this is a public YouTube video kabatti, I don't want to tell certain abusive methods followed by the law enforcement agencies also. Well, sometimes they use it, like third degree treatment is never on the record, but they do third degree treatment to extract the truth or facts or whatever the facts of the case.
Yes.
So likewise, they are forcing undue SIM card insertion, saying that this device has used this SIM card. But what happens to the electronic activation? There is a transfer ID, there is a transaction ID. That is only a digital forensic analyst can tell. You common man people cannot know that. But you are under the impression, oh, you are caught, this is the phone. You are caught, this is the SIM. So you better confess. They'll force you to confess because of your ignorance, because ignorance is a bliss. Followed, your question is answered.
Yes,
There
sir,
are the dubious methods, which is not fair, but yet they are being used.
అండ్ కొన్ని కేసెస్లలో CDR డీటెయిల్స్ కలెక్ట్ చేస్తున్నారు సార్.
Okay.
ఆ CDR డీటెయిల్స్ లో ఏదైతే ఫోన్ నంబర్, పర్టికులర్ ఫోన్ నంబర్ ఉందో దానికి సంబంధించిన కాల్ రికార్డ్ డీటెయిల్స్ మొత్తం వస్తాయి.
దాన్ని కాల్ డేటా రికార్డ్, CDR అంటే కాల్ డేటా రికార్డ్. ఈచ్ has got an, ఇందాకేం చెప్పిన, టైమ్ స్టాంప్ ఇస్ దేర్, డేట్ స్టాంప్ ఇస్ దేర్. ఎవ్రీ హాపింగ్ అంటే ఇవన్నీ day 1 day 2లో చెప్పేశాను. హాపింగ్ అంటే నౌ యువర్ కాలింగ్, it's not an international call. If it is an international call in Bombay or Mumbai, there is a transponder which transmits your signal, this telephonic signal, to an international interceptor or international intermediary, where it transponds your local signal to global signal. Understood? So there is a transponder in between, acting as an intermediary. Likewise, you apply this technology to every call which is made in a typical call data required. So immediate call goes to the nearest pole or nearest
pole.
Yes. So that has got an identity. So it has got its own IP address, which has got certain characteristics where it transmits to several other agencies or exchanges. And those exchanges are cascaded, pulled up, and channelized and beamed through an international transponder, which hooks up through a satellite connectivity. So there is an uplink and a downlink. So uplink cascaded all these calls going through the pipe, and that pipe is also like encryption, decryption, ciphering, and deciphering. All these are into picture. So this is a huge technology to discuss about, but it's beyond our scope.
ఒక ఫోన్ లో ఎన్ని సిమ్ కార్డ్స్ యూజ్ చేశారు అనేది తెలుసుకోవడానికి ఏమైనా టెక్నిక్స్ ఉన్నాయా? ఈవెన్ పోలీస్ డిపార్ట్మెంట్స్ ఆల్సో.
There are. Everybody, see, I will tell you, though this is a Nokia, this is only single. Whereas other one has two mobiles, but I am only using one. So naturally, the operating system.
సారీ సార్, నేను అడుగుతుంది ఒకటే ఫోన్ లా ఎన్ని సిమ్ కార్డ్స్ యూజ్ చేశారు అనేది ఎవరైనా చెప్పగలరా? దానికి సంబంధించింది ఎవరైనా సర్టిఫైడ్ కాపీస్ ప్రొవైడ్ చేయగలరా పోలీస్ వాళ్ళకి కానీ?
See, Ramakrishna, I will tell you. See, this laptop is there, right? How many USB pins sockets are there? The model will tell. Number one. So, established fact that this phone has two slots for two SIMs to be inserted apart from the SD card. Followed? So, the model describes it that it has the capability of allowing two SIMs to be inserted. Point number one. Now, on booting, it will activate both. If two SIMs are inserted, both the SIMs and their call towers are invoked, because one is Airtel, one is BSNL, for example. So BSNL will be said hello 10:30. BSNL tower is handshaken. Airtel's tower is also handshaken. Now, the user has an option to switch to SIM 1 or SIM 2 to make a call, right? So when Airtel is activated, or Airtel, both are activated. When Airtel has to be used to call a particular friend or a foe, you are using Airtel. Then you have the ability as a user to switch from Airtel to BSNL. Then once the call is initiated, your CDR gives the entire imprint from sender to the receiver. What else you want?
సార్, నేను అడుగుతున్న క్వశ్చన్ ఏంటంటే, ఒక సిమ్ వాడిన తర్వాత
there is a footprint that two SIMs are being used, yes or no? People, yes, I will tell you, the miscreant will give only one SIM number, right? Such and Caesar will give two SIMs are there. On the digital forensic analysis, two SIMs phone is discovered, two SIMs activated discovered, but only few calls are made by SIM 1, and all the calls, regular calls, are made through SIM 2. These are all part of the forensic analysis, Ramakrishna. What else you need? It will be discovered. It will be, police can identify. That is what digital forensics is all about. Anything else?
అది ఎవరన్నా సర్టిఫై చేస్తారా సార్? ఫర్ ఎగ్జాంపుల్ ఒక 10 to 15 సిమ్ కార్డ్స్ ఉన్నాయి సార్. సిమ్ కార్డ్స్ ఉన్నాయి. సో 2 స్లాట్స్ ఉన్నాయి. సో నేను మార్నింగ్ 9 o'clock కి 2 సిమ్స్ వాడుతున్నా. సో మధ్యాహ్నం 11 కి ఇంకో 2 సిమ్స్ వాడుతున్నా. అలా నేను 3 days లో 15 to 20 సిమ్ కార్డ్స్ వాడుతున్నా. ఇప్పుడు ఆ డీటెయిల్స్ అన్ని కూడా వస్తాయా సార్?
అన్ని వస్తాయి.
ఐ హోప్ యు గాట్ యువర్ ఆన్సర్ అనుకుంటా రామకృష్ణ గారు.
అన్ని సిమ్స్ వాడుతున్నట్లు ఎవరైనా సర్టిఫైడ్ చేయగలరా? That is the question.
I'm a digital forensic expert. Expert and a consultant, who I will give you as an expert opinion. My report has that, which is globally accepted. I'm a CISA, Platinum Consultant, Certified Information Systems Auditor, with a digital forensic analysis as a specialization. We have some tools to do that. Any question?
రామకృష్ణ గారు మీకు ఆన్సర్ వచ్చింది అనుకుంటున్నా నేనైతే. Thank you, sir. Got the answer.
Welcome, madam. So we'll conclude the session. It is 10:33. Hope you all had dinner and anxiously waiting to close to hit the sack. I mean, go to bed.
Okay.
We are having
you, sir.
dinner from last 1 hour, sir. Your words are our dinner.
Oh my God! Thank you very much, madam. You made my day.
Thank you, sir.
All
Thank you, sir.
all
Good
the
night, sir.
hungry got vanished.
Yes.
Thank you, sir. Thank you so
God
much.
bless you.
Thank you, sir. Good night, sir.
Right, sir. Good night. Good night, everybody. I'm
night, sir.
closing. Thank you. Thank you very much.
Thank you so much.
Thank you, sir. Thank you. Good night.
Thank you. Thank you, ma'am.
Thank you very much, all.